Every day, millions of dollars change hands through checks, drafts, and negotiable instruments. But what happens when the person handling that instrument owes a duty of trust and secretly betrays it? A fiduciary is someone entrusted to act for another person's benefit. That could be an agent, a trustee, a business partner, a corporate officer, a director, or any representative who owes a legal duty of loyalty and honesty regarding an instrument. Trust is their currency. Integrity is their obligation. Section 3-307 doesn't automatically presume wrongdoing. Instead, three conditions must first exist. First, the instrument is received for payment, collection, or value. Second, the recipient knows the person handling it is acting as a fiduciary. Third, the represented person later claims the fiduciary violated that duty. Only then do the notice rules come into play. Once those conditions are met, notice of the fiduciary's breach becomes notice of the represented person's claim. In other words, a recipient cannot always ignore obvious warning signs. Knowledge can carry legal consequences. Imagine a trustee uses trust funds to pay off their own personal debt. If the recipient knows that debt belongs to the fiduciary personally, the law says the recipient has notice of the possible breach. That transaction raises an immediate legal red flag. Another warning sign appears when the instrument benefits the fiduciary personally. If the recipient knows the transaction serves the fiduciary's private interests rather than the represented person's interests, notice may exist. The third warning sign concerns where the money goes. If an instrument payable to the represented person or fiduciary is deposited into an unrelated account instead of an authorized fiduciary account or the represented person's account, the unusual destination itself may provide notice of a possible breach. But the law also recognizes that not every unusual transaction signals misconduct. If the represented person issues an instrument payable directly to the fiduciary personally, the recipient does not automatically have notice of wrongdoing. Actual knowledge of the breach is required before notice exists. Finally, when the instrument is issued directly to the recipient, the same warning signs return. Is it paying the fiduciary's personal debt? Is it being deposited into an unauthorized account? If the recipient knows these facts, the law says notice exists. UCC Section 3-307 does not declare every fiduciary transaction improper. Instead, it establishes when circumstances become suspicious enough that the law treats a recipient as having notice of a possible breach of fiduciary duty. The purpose is straightforward: protect those who place their trust in others, while encouraging honesty, vigilance, and accountability in commercial transactions. Section 3-307 reminds us that trust carries responsibility, and when warning signs are apparent, the law may attribute notice to those who knowingly participate in a transaction involving a fiduciary. As with any legal issue, the application of this section depends on the specific circumstances of the case.